Poverty is not just the absence of money, but the absence of opportunity. And the United States is a country where you have both freedom and abundant opportunities. And moving to the United States has given me both. I grew up in Lagos, Nigeria. I came from a close-knit family. I was the third of four children. And the best thing that my parents gave me was the gift of education. Even though I came from a poor family, they gave me education with the instruction that this is the tool that will help me to dig my way out of poverty and ignorance. But what my parents did was that they instilled in us the value of faith, hard work, and not giving up. They made us realize that if you put in the work, you will definitely get the reward. I came without a dime in my pocket. All I had was big dreams, determination to succeed, and the resilience. I got my first job at the age of 14. My job was on a construction site. My duties were to move concrete on a large pan from one end of the construction site to another one. I worked on that day from around 6 in the morning to about 7 at night. At the end of the day, the employer refused to pay me. And the reason was because she did not authorize the foreman to hire me. So I worked from sunup to sundown and didn't get paid. That tore up my spirit. And from that moment on, I decided that I was going to become a lawyer. And I was going to use every ounce of strength within me to fight against injustice, regardless of how powerful the opponent is. I am a man that worked my way up from nothing. I know what it means to feel like you're being unfairly treated, and I'm the person that can stand up to opponents regardless of how big or how powerful they are. Welcome to this episode of Legal Angle with Emmanuel the Law Olawale. My guest today is attorney Felice Harris. She is an appellate attorney. She handles both criminal and civil cases. Welcome to the show, Felice.
Thank you, Emmanuel.
And a lot of people watching the show may not know who you are. So, although I've given a brief introduction about who you are, can you tell us a bit more about yourself?
So like you said, I'm an appellate attorney. I do civil and criminal appeals, but I got into the profession originally through the Ohio Public Defender's Office. And I was assigned to their appellate division, and that's where I really got to understand what happens at trial and the errors that happen at trial and why it's so important to have a good attorney on appeal. Because where a trial attorney makes the most difference, and I always tell my client to put everything they have into the trial. If you lose at trial, your next best shot is on appeal because you need somebody who can really see the errors that happen at trial in order to correct them on appeal.
Thank you. And you happen to be an attorney that has diverse background. But before we even get to some of the experiences that you've had, how did you decide to become an attorney? What inspired you?
I kind of back ended into becoming an attorney, actually. So I became an attorney actually because I was studying the LSAT with a friend of mine who wanted to become a lawyer, and she needed a study partner. And so I studied with her for the LSAT, and we did all of those tests together, all of those pre-tests together. And finally she said, well, you've done all of this with me. You might as well take the test. And so I did. And then 5 years later, I got a notice in the mail that my tests were about to expire. And so that's why I decided to go to law school. And so ultimately, that's how I ended up becoming a lawyer. Um, yeah. So that, I know there are a lot of people who from young age say, I want to be a lawyer. That was not my journey. Like I said, I back-ended into it.
So you did like a pact with your friend, did the LSAT together, and you got stuck with the results. So you ended up going to law school.
That was it. That's how I ended up going to law school. And kind of the same thing, how I ended up at the public defender's office. I was lucky enough through the Columbus Bar Association to get a minority clerkship that initially put me in the public defender's office. And then when I graduated, my first job was in the public defender's office. And public service is so important because people who can't afford an attorney, they get assigned public defenders. And I know there's, public defenders have such a bad rap. And they are overworked and underpaid. But I worked for the state public defender's office, and there are some very fundamental differences between the state public defender's office and a lot of county public defender's offices. And one of those differences, I think, is that the state public defender's office is very well funded and very well staffed. But I had an excellent training at the state public defender's office. And again, I worked in the appellate division, and that's how I really got a love for what I do.
And you went to Denison University for your undergrad.
I did.
What did you study? What was your major? And when you were during your undergrad, what were your aspirations?
So I double majored in psychology and English, and I've always loved to write. As you can tell, I'm an appellate attorney, but I've always loved to write, and so I was an English major. But I've always been interested in how people think and how people process and what people believe and how they get to those beliefs. And psychology always interested me, and that's why I was a psychology major. So yeah, I double majored all the way through.
So if you weren't an attorney, you'll be a writer or a psychologist. Yeah.
It's interesting. I'm not sure what I would have done with, I don't know what you do with a double major, from a liberal arts college with a double major in psychology and English. But, I picked something that interested me and then something that I enjoyed doing. Yeah, and then what I was going to do with them once I graduated, I'm not sure, but yeah, that's what I majored in undergrad.
Even after you became an attorney, you still took a detour back to counseling, which is you as a counselor or educator. Can you tell us about that?
Yeah, so I had a long road. So I love school. That's the thing. I really enjoy learning. I think learning is a lifelong process. There are 1,000 things you can learn and continue to learn. And so I eventually went back to school and I got a master's in counseling. In school counseling. And then I also am ABD, it's all but dissertation, for a PhD in criminal justice with a focus on forensic psychology.
Okay. So, oh my God, in one person. So, as an appellate attorney with all this, diverse background, how has the things you've done, both as all the education you've had, all your life experiences, your professional experiences, before you started your own practice, being an appellate attorney, how has those experiences informed the way you advocate for your client?
So I think the counseling and the psychology has really helped because I think it has helped me kind of come to understand how people think. Um, Everybody comes to where they are from different places. And I think having the counselor background, number one, lets me understand that everybody is at a different place when they get to my office. So when you come and you get to either the trial services or the appellate services, everybody is coming there from a different place. Everybody has a different perspective. Everybody had different upbringing. And you really need to understand that when you're in criminal law, you really need to be open-minded and understand that everybody is not coming from the same place. Everybody has not had the same life experiences. And so you really need to be open about that. And having a counselor and a psychology background has really helped me with that.
Great. And when you worked at the public defender's office as an appellate attorney, but they only handle criminal cases, what got you into civil cases?
So I was of counsel. I'm still actually of counsel with another firm, and they do civil cases. And so, um, in working with that other firm, I started doing civil cases. But I had also left law for a little bit, and I was just doing legal writing for other attorneys. And in the legal writing for other attorneys, it was only actually, it was probably 90% civil, and so that really got me onto the civil side.
Oh, great. And you also, spent your time supervising in the Juvenile Division.
Yep.
Uh, can you tell us a bit about that?
Yeah. So at the public defender's office, I started in the appellate division. I left for a while and I was at the city prosecutor's office. And so I have experience both on the defense side and the prosecution side. But when I came back to the public defender's office, I was eventually promoted to the supervisor of the juvenile division. And so I was at that position at that level. And so I managed a staff and, managed budgets. And it was a different experience than, being I don't want to say a line attorney, but it was different being management than being a line attorney because you have different responsibilities.
Thank you. And when you decided to open your practice in 2009, you could have decided to, do general practice, do trial practice, or any other areas of practice, even transactional practice. You decide to focus solely on appeals. Why just appeals?
So initially in 2009, I was doing trials. I was doing trial work. So I was doing juvenile, I was doing A&D, which is abuse, neglect, dependency cases, and I was doing appeals. So it was a little broader than what it is now. Um, and it was busier because it was broader. So to go from trial work and the writing, it's a lot. And eventually I decided I wanted to narrow it down to what I enjoyed the most, which is appellate writing. I really enjoy the research and writing. When you do trial work, you will, at least at that time, you tend to be down at the courthouse a lot. You would spend, yeah, all morning, 9 to noon, Monday through Friday, at the courthouse because your cases are stacked, and you literally are there all morning, 9 to noon. So eventually, I decided what I really want to do is just focus on what I enjoy the most. And so I weeded out the trial practice, and now I just do appellate work.
So you just focused on what you enjoyed the most.
Yes.
Wow. And part of what you enjoy, you mentioned it, learning and going to school. At some point, you decided to pursue a PhD in criminal justice. Was that after you got your law degree, which is already a doctorate, or was it before?
Oh, that was after. That was after. It was several years after the law degree. I was thinking about how to expand my knowledge base. And at the time, I was supervisor of the juvenile section, or I had been supervisor of the juvenile section. Um, and I knew what was going on in juvenile court. And at that time, we weren't really doing a lot of competency evaluations for juveniles. We weren't doing a lot of the forensic work in juvenile court. And that was going to be the focus of my PhD. And so I thought, why not go back to school, get a PhD, and do, focus on the forensic side of it. And that's what I did. Like I said, I love learning. There is always something that you don't know. Um, and that's what I was interested in at the time.
Just learning. Yeah, you're a consummate learner. So how do you stay abreast of the evolving landscape of appellate practice?
So I wish there were more CLEs. So there's always, the continuing legal education. There's not as many for appellate practice as there should be, but there's always case law coming out, right? There's always new decisions coming out. Most of which I don't agree with, but there's always new law being made. And that is the way to stay abreast of what's going on, what's going on in what appellate division, and then of course being active kind of in the different chat rooms, the different groups that lawyers have. That's how I try and stay aware of what's going on.
Oh, thank you. And post-conviction practice, especially filing post-trial motions, appeals, can be lengthy and it can take a lot of time, even sometimes years, with a lot of disappointment on the way. It's very complex. How do you handle this?
So the first thing is to make sure the clients are aware of the deadlines. There's timely post convictions, and then there are delayed post convictions. I try to stay away from the delayed post convictions because the standard of review is so high for delayed post convictions. So again, the first thing is trying to differentiate whether the post conviction is timely, or delayed. And the way Ohio law stands, to be timely, you have to file a post conviction petition within 365 days of when you would have appealed your conviction. So essentially it's 365 days plus a month of the day you were convicted, more or less, if you think about it that way. For delayed post conviction, you can file it, but the standard of review is essentially whatever evidence you're bringing forth has to be such that no reasonable juror would have convicted you. And if you think about that, that is a really high standard. That is really difficult, to think that you have to come up with evidence that no reasonable juror would have convicted you. So that's really the first thing, is to make sure your clients know the different standards and to make sure they get their post-conviction petition in time, which is within 365 days plus 1 month of the day they were convicted.
Thank you. How about in civil practice? What is the deadline to file an appeal?
So it's the same thing. You've got the deadline to file an appeal is 30 days. You've got 30 days from the date of the judgment entry. So whether that's civil or criminal, you've got 30 days to file a notice of appeal from the date of the judgment entry. The only way that changes, or reason that changes, is if you had some kind of hearing in front of a magistrate. Because if it was in front of the magistrate, then you've got to file objections before you can file the appeal.
Okay. And if you file the objection before the magistrate, if the objection is sustained, then what happened?
So after you file the objections, then once the judge files the judgment entry, then you've got 30 days from the date of the judgment entry to file your notice of appeal.
Okay. So if the judge sustains the magistrate's decision, then you have to file an appeal.
Right.
But if the judge overturns the magistrate decision, you stay on in trial court.
Well, so if the judge sustains whatever the new entry is, so I'm assuming if the judge reversed the magistrate's decision, then maybe you're happy with the decision and you don't want to appeal. But if the judge, sustains the magistrate's opinion and you weren't happy with that magistrate's opinion, then you would appeal that new judgment entry.
And in a situation where they are still at the magistrate level and the magistrate denies, maybe the motion or rules, do you handle those kind of cases, or it has to be a judicial final judge's entry before you can step in?
So that's interesting. So I've been asked to handle those and I don't. And there's the reason I don't is because you've got 14 days to file objections. And I can't get up to speed on a case in 14 days and file an objections. The person who's in the best position to do that is the trial attorney. So whoever was handling that trial, who has been on it for all of that time and who had it before the magistrate issued that decision, is in the best position to go ahead and file those objections. And then after the judge issues whatever decision the judge issues, then you've got 30 days to file the notice of appeal, and then that's when you would call me.
Okay. Can you share a notable civil case you've handled without having to name the client? Just give us the fact and what happened.
So I've got a case on appeal now, a civil case on appeal now. It is it's a breach of contract case. So it's a home improvement case gone bad. And let's see, so the contractor, well, so it was a home improvement contract. The contractor claimed that the homeowner, who I represent, breached the contract. The trial court agreed and also determined that the homeowner acted in bad faith. And what that did was allowed the contractor to also get attorney's fees. So on appeal, of course, I argued that the contractor actually breached the contract and that the trial court was wrong in determining that my client acted in bad faith. So we just had oral argument on that maybe 2 months ago, maybe not that long ago. And so we're waiting for the decision in that.
How do you prepare yourself for oral argument?
Well, a lot of repetition. So I usually review the briefs and the exhibits. So if it's a long case, like this particular civil case had a lot of exhibits. And so it was reviewing the briefs and the exhibits. And then I ask myself what the story is. And I try and write what the story is and then incorporate whatever the errors are into the story. I think it makes more sense and is more persuasive when you argue whatever your errors are in a story. It's when you're presenting a case to 3 judges. So the Court of Appeals is a panel of 3 judges, and oral argument is before a panel of 3 judges, and they've read your briefs, and so they're a little familiar with it. But when you're trying to persuade them about something, I think it's more persuasive when you tell the story as opposed to just argue, whatever your assignments of error are. And so when I prepare for oral argument, I try and figure out really what is the story, and then I incorporate the assignments of error into the story.
Okay. And you did the same with both criminal and civil cases?
Yes, to the extent I can, because there really is always a story. Sometimes it's not as cohesive as you would like it to be, but there really is always a story. Because at trial, when the prosecutor puts together a case, they're telling a story. So on appeal, you might have to rework the story, but there's always a story. When the prosecutor is putting together a case at trial, they're always telling a story. So you may have to rework the story or reword the story to your advantage, but there's always a story.
There's always a story. Can
There
you
is.
tell us a story about a notable criminal case you've handled or that you are handling?
Let's see. That's interesting. Who am I handling? I've got this is another one. So this is an interesting case. I'm waiting for notice for oral argument. We just finished doing the briefs, but it's a NGRI case. So it's a not guilty by reason of insanity case, which these cases don't come up very often. And so you're likely to have, I shouldn't say that. Maybe you're not likely to have errors, but in this case, there were a lot of errors. And I think it was because these cases don't come up often. And so the prosecution made errors, the defense counsel made errors, or at least that's what I'm alleging, that everybody made errors, including the trial court. And so one of the major errors is that when you have everybody has a right to a jury trial. When you have like a felony case, you have a right to a jury trial. If you're going to waive that right, you actually have to sign a waiver, a written waiver, and then the court has to, it's called address you on the record, meaning when you're in front of the court, the judge has to ask you if you have signed that waiver and you are in fact waiving your right to jury trial. And in this case, that did not happen. There is no written waiver, and the trial court did not address the client. So that is one of the issues that I raised on appeal. And so we'll wait to see what happens with that.
Okay. And while an appeal is pending, what happens to the convicted client?
Well, so you have the option while an appeal is pending, you can always file for bond pending appeal. The problem is that it's very rarely granted. And so all of my clients are in custody, meaning in prison, while their appeal is pending. The one who was not guilty by reason of insanity, they're not in prison, but they're in a different kind of custody. So you can always apply for appellate bond. It's just very, very, very rarely granted.
So, how do you communicate with your clients who are in custody?
Oh, so I get calls all the time. Actually, yeah. So I accept prepaid calls from clients all the time. It's no different than anyone else. My clients who are in prison, they can call from their GTL tablets, and they call me. I'm usually whitelisted as their attorney of record, and then they call me from their GTL tablets. I mean, we write also, but yeah, that's primarily it. And the thing with one of the first things I tell my clients is attorney-client privilege attaches. So when they contact me or when I contact them. So even though prison calls are recorded, when we communicate, whatever they say to me directly or I say to them directly cannot be used against them unless they break attorney-client privilege by doing a three-way call. So three-way calls are not privileged. Direct contact is privileged. So when they call me directly, it's a privileged conversation. If they do a three-way call, it is not privileged.
Thank you. So when you say it's a privileged conversation, does that mean that the prison cannot record that call?
It's recorded, but they can't use any of that information.
Okay. If they can't use the information, what if they listen to the call, get the information, give it to the prosecutor, and the prosecutor investigated that, whatever they can get from that conversation?
It would, so in that, they wouldn't be able to use it. Any information that came out of a prison phone call, a recorded call through an attorney, would have to be suppressed because it was privileged in that conversation.
And talking about writing, how do you approach the task of writing a compelling appellate brief? What's your strategy?
So when I'm writing an appeal, right, I have to read the transcript. So I read the transcript, I review all of the court documents, and I review the discovery. And as I'm reviewing all of this, I'm taking notes. And at this point, I'm going to age myself, but I've been doing it so long that usually as I go along, things will pop out at me that I'll just write, and that might not seem right, or that doesn't seem right. I'll put little stars, check this later. And that is generally how it happens at this point, because I've been doing this for over 20 years. so at this point, I hate to say that that's my strategy. There probably was a strategy 20 years ago when I started, but at this point, because I just been doing it so long, things just, as I read along, I just like that's not right. Let's star that, come back to that. Because as I'm reading and going along, I, like the jury waiver issue, there's just some things to check. Like for every guilty plea, when I'm reviewing a case, a guilty plea appeal, I know that for a plea to be knowingly, voluntarily, and intelligently entered, the court has to abide by the Criminal Rule 11 colloquy, which essentially means the court has to go over 6 constitutional rights. And I know what the 6 are. The court has to tell the defendant they're waiving their right to jury trial. They have to be advised that they have to be found guilty beyond a reasonable doubt. They have to be advised that they have the right to subpoena people. Like there's a list of rights that they have to be advised of. And at this point, I've been doing this for so long, when I'm going over that guilty plea transcript, I know that I can read it and check off whether the trial court advised them of their rights, and at the end, whether they advised them of their right to appeal. So there are just things that the more you do it, you kind of know what to look for. Now, in the same vein, I also know that certain courts, where they should be reading the Criminal Rule 11 colloquy from the book, they believe they've been doing it so long that they don't need to read it from the book, and sometimes they skip things inadvertently, and then that's an appealable issue.
Oh, thank you. So you've been doing it for so long, you've mastered it. So it just pops out to you. It becomes second nature.
I wouldn't say I've mastered it, but I've gotten good at what I do because I've been doing it for a while now.
And what strategies do you use when educating or arguing before a panel of judges where one or two of those judges don't have the background in that area of law? Let's say criminal case, for instance, because you might have a judge who's never practiced criminal law, who's never prosecuted it. What strategy do you use to educate a panel like that?
I don't think I use any different strategy. I think that's part of the story. I think that's part of why I try and craft a story and incorporate the assignments of error into the story. Because if you make it as simple as possible, then even someone who does not practice that area of law can understand and follow the story. If I'm arguing that the evidence is insufficient because they didn't prove an element of burglary, and I say these are the 3 elements, and this is the one they didn't prove because XYZ, that should be easy to follow, even if your background isn't in criminal law.
Thank you. And when you're writing your brief, how extensive do you have to do legal research?
I'm sorry?
When you're writing your brief,
Hmm.
How extensive do you have to do like legal research, or do you use more of the factual argument without a lot of legal research?
It depends on what the issue is. I I feel like there's every case is something new except for a guilty plea appeal. You know, this particular case that was not guilty by reason of insanity was after 20 years was my very first not guilty by reason of insanity. Um, you know, I've got a custody appeal right now, and every custody appeal is, you know, a little bit different. The civil appeals, even a breach of contract claim, it's every civil appeal is a little bit different. Um, the criminal appeals, because the facts are always different, the research is always slightly different. And then because the districts are different, the research is going to be different. So, so I feel like it's always fact and research intensive.
Thank you. Do you have to discuss your strategy with your client?
I usually don't. I usually don't discuss my strategy with the client. And I usually don't have that much contact with the client while I'm writing the brief. And that's usually because of the time limits. So with an appeal, so you file the notice of appeal, and then you're essentially waiting for the reporter to file the transcript. But after the court reporter files the transcript, you've got 20 days to file that brief. And during those 20 days, you're reading the transcript, which on average is between, you know, 900 and 1,200 pages. So you're reading the transcript, you're conducting your research, you're reading all the court documents that were filed, and you're reviewing the discovery. And then you're writing your brief, all in those 20 days. So because my clients are in prison, most of them, I I'm not writing back and forth during those 20 days. I'm usually, you know, reading all of that and doing the research and writing the merit brief in those 20 days.
Thank you. And how do you manage the expectations of your client?
I usually tell them up front what's happening. You know, in the very first letter, I usually say, so this is how the appellate process works. Um, we're going to file the notice of appeal. In the next 40 days, the court reporter is going to file the transcript. And then I've got 20 days and I'm going to file the merit brief. And then after that, the prosecutor has 20 days to file their brief. And then I've got 10 days to file the reply brief. You know, this is, you know, I lay out, this is how it works. Um, you know, you're free to call me um, and find out kind of what's going on. But generally, I kind of lay out what the process is, um, you know, and how our contact works. And they get copies of everything that's filed in their case, either that I file or the state files. So I try and keep them abreast of everything. And, you know, if they have any questions, anybody's, you know, always free to call me. But usually while I'm writing the brief, um, we're not kind of going back and forth of like what I'm finding in the transcript. There just isn't time for that.
Thank you. How do you explain the complex legal concepts to your clients who have no legal background, and it's still their case, and they call you to want to know what's going on? How do you break down those things that you've done to a level where they can understand?
And usually it's not that hard because they've sat through the trial. So usually they've got at least a baseline from sitting through the trial. And remember that the appeal is based on what happened at trial. So I can say, okay, so remember when the prosecutor or your defense attorney did this? well, that was wrong. And so I'm challenging, what happened at trial. So usually I can refer back to whatever it was that happened at trial, and it gives them a reference point. So even for somebody who's not well versed in criminal law, who, the trial may have been their very first contact with the justice system, it's not too difficult to explain what's going on in the appeal.
Thank you. And can you educate us about the differences between oral advocacy at the appellate level and, and compared to the trial court, where you have to call witnesses, present evidence, and
Oh
opening
yeah.
argument, closing argument?
Yeah, so it's completely different. And this is what I explain to clients. At the trial level, at the trial level, you wait and wait and wait while it's continued, and then everything happens very fast at trial. So at the trial level, with the trial, you do call witnesses, and everything happens right there in the trial court. At the appellate level, everything happens on paper. We only appear in court for oral argument, and that is at the very end. So whereas at the trial, it's all gearing up for that trial where everything is in front of a single judge and you get to call witnesses and the defendant gets to be there and you actually present your case. At the appellate level, everything happens on paper where we're writing briefs. So remember, I talked about the transcript that's filed. I write the merit brief, the state responds in their merit brief, and then the defendant gets to write a reply. So everything happens on paper, and then we do an oral argument before the Court of Appeals, which is that 3-judge panel. And that's the only time we ever appear in court is at oral argument. So it is completely different from what happens in the trial court.
Okay. And after the Court of Appeals, let's assume that your client did not succeed. What happens next?
So there are a few options. You can actually, there are 3 options. You can appeal upward to the Ohio Supreme Court. And if you do that, that is called filing a memorandum in support of jurisdiction to the Ohio Supreme Court. You can go back to the same Court of Appeals in a motion to reconsider, but that's very narrow. You can only do a motion to reconsider if the Court of Appeals missed an issue, not just because you disagree with what they said, but let's say you, in your appeal, you raised 5 assignments of error, but they only addressed 4. So you can do a motion to reconsider and say, hey, you missed this issue. And then the third option you have is called an application to reopen the appeal. And that's based on ineffective assistance of appellate counsel. So let's say, right, you lost your appeal, but you think your appellate attorney did a bad job. You can hire another appellate attorney and say, hey, I want you to review everything that my prior attorney did and see if you can find anything that they missed. And if they missed something, you can file an application to reopen the appeal in the Court of Appeals. So those are the 3 options. There's the memo in support of jurisdiction to the Ohio Supreme Court, and you have 45 days to do that. You have the application to reopen the appeal in the Court of Appeals. You have 90 days to do that. And then you have the motion to reconsider back in the Court of Appeals, and you have 10 days to do that.
Thank you. And if your case makes it up to the Supreme Court, what is the process? Is it just like the middle level, or is it a totally different
It is a
process?
totally different process. So the notice of appeal and a memorandum in support of jurisdiction. So the memorandum in support of jurisdiction is like a mini brief, and it is saying it's essentially your petition to the Ohio Supreme Court as to why they should take your case. Because in the Court of Appeals, in a criminal case, the Court of Appeals has to take your case. You have an appeal of right in a criminal appeal. So if you file a notice of appeal, the Court of Appeals has to take and decide your case. That is not so in the Ohio Supreme Court. And so when you file the notice of appeal and the memorandum in support of jurisdiction, the memorandum in support is the memo saying, hey, please take my case, and this is why you should take my case. And then they read it and they decide, yay, I want to take your case, or nay, I don't want to take your case. If they decide to take your case, then it goes forward, and then it's on a regular briefing schedule where you then have to file the regular merit brief, and then the state or whoever is opposing you gets to file their brief also.
Okay. And is it the same for civil cases?
For civil cases, no. Well, actually, let me take that back. I don't know. I know for administrative cases, it's different. I do not know for civil cases.
Okay. And for civil cases in the Court of Appeals, if let's say you don't succeed, what's next?
So for civil cases, it could be the same thing. Civil cases can also go up on a memo in support to the Ohio Supreme Court. Yeah, so you can take civil cases up. I'm just not aware of the process as much because I do criminal cases mostly.
Okay. And talking about evidence, can you present new evidence on appeal?
No. So on an appeal, you can only raise what was raised in the trial court. You cannot present new evidence on an appeal. If you have evidence that didn't make it into trial and you believe should have made it into trial or could have changed your case, that should be filed in a petition for post-conviction relief. So that's what we talked about, that you've got that 365 days plus, about a month for. But basically, if you have, let's say you had, evidence, maybe you had an alibi, but that alibi evidence was never raised at trial, you could file a petition for post-conviction relief based on that evidence. But yeah, anything that didn't make it into trial cannot be raised on an appeal.
Thank you. And while filing a criminal appeal, let's assume that someone was charged with several counts of a crime, and they get convicted of, let's say all of them, let's say 10, for instance. Is it possible to challenge some counts and not others on appeal? Or do you have to appeal the whole conviction?
No, so if you're the one filing the appeal, you can raise whatever you want. You don't have to challenge all of them. You can challenge some of them. You can challenge just the sentence if you want. But generally, so on appeal, you can challenge the sentence if it's illegal, but generally you're challenging the conviction. And if you can overturn the conviction, then necessarily you also overturn the sentence.
Okay, but it's also possible to challenge the sentence alone without actually challenging the conviction?
Yes, if the sentence is illegal.
Okay, and how would you describe an illegal sentence?
So Ohio has sentencing ranges. Let's say an F2 is 2 to 8 years. In other words, 2, 3, 4, 5, 6, 7, or 8 years. Let's assume in Ohio, you can get either 2, 3, 4, 5, 6, 7, or 8 years. But at your sentence, your trial court sentences you to 9 years. Well, that's an illegal sentence. And so on appeal, you could challenge that sentence.
Okay, so and if you succeed on appeal and they send the case back to the trial court, does that mean that the trial court have to resentence you?
Yes. If the only thing you challenge on appeal would be that sentence, then it's going to be remanded just for resentencing.
Okay, if at that point it's remanded and you decided that you want to challenge the conviction itself, can you still do that?
No, because then you missed your window to appeal.
Okay, so let's say you miss your deadline to appeal. Is it possible to file a motion with the court for an extension of time and give them a good reason why you missed the deadline?
So in Ohio, There is for criminal cases, there's no such thing for civil cases, but for criminal cases, there is such thing as a motion for leave to file a delayed appeal, but you have to show good cause. And essentially, good cause for criminal cases is you were not informed of your right to appeal. And that's going to appear on the face of the transcript. So at your sentencing hearing, at the end of the sentencing hearing, the trial court has to inform you of your right to appeal. If the trial court does not inform you or misinforms you, which I've just read last week, misinforms you, in other words, tells you you don't have the right to appeal, then that is grounds for leave to file a delayed appeal.
Okay, so is it possible that a trial court would tell a litigant or a defendant that they don't have a right to appeal?
That, unfortunately, that is possible. That has recently happened. That has recently happened, and where I see it most is when defendants plead guilty, the court will mistakenly tell them that they don't have the right to appeal.
Thank you. And mentioning about pleading guilty, the question is, if and when a defendant plead guilty, can they still file an appeal?
Absolutely. You can always appeal a guilty plea. Absolutely.
And what is going to be the ground for it, since they decided to plead guilty?
So the only grounds for appealing a guilty plea is always going to be that the plea was not knowingly, intelligently, and voluntarily entered. That is your only grounds to appeal a guilty plea. It's going to be that, and or that there's a problem with the sentence. So when you plead guilty, you are waiving everything else except that the plea was not, knowingly, intelligently, and voluntarily entered, or that the trial court somehow messed up the sentence.
Okay. And in situations where someone has counsel, how can they make the argument that they did not knowingly or intelligently decide to take a plea?
Because that whether the plea was knowingly, intelligently, and voluntarily entered actually has nothing to do with the defendant. It only has to do with whether the trial court informed the defendant of the rights he was waiving. That goes back to that criminal rule 11 colloquy, and whether the trial court informed the defendant that he was waiving his right to be found guilty beyond a reasonable doubt. He was waiving his right to subpoena witnesses to testify on his behalf. He was waiving the right not to testify. There's like six constitutional rights that the trial court has to inform the defendant of during a guilty plea. And if the trial court does not inform the defendant of those six rights, that's what makes the plea not knowingly, intelligently, and voluntarily entered. So it really doesn't have to do with the defendant at all. It has to do with the trial court.
Okay, so is the higher court holding the trial court accountable for what they should have done, regardless of whether or not the defendant raised that issue?
Exactly.
Okay, thank you. And for those who, for young attorneys who are thinking of going into appellate practice, what advice will you have for them?
Do what you love. If you enjoy research and writing, appellate practice is for you. I mean, it really is. I love the research and writing. No two cases are the same. And so it is going to make you delve into the research to find the answers. The only thing that's the same all the time is a guilty plea. Actually, that's not even the same all the time. But for a guilty plea appeal, you're looking at the criminal rule 11 colloquy. You're always going to look at that. But for any other case, it's always different. And so there's always research. If you like having to find the answers, if you like, coming up with something new with every case, appellate practice is for you.
Thank you. And how do you balance the rigors of this work, the research, the argument, the oral argument, the anticipation, the waiting game. How do you balance that with your mental health?
You stay organized. You really have to stay organized. You have to stay organized and keep a good calendar to stay on top of everything. And then I'm trying to stay balanced. Sometimes it gets away from me. I work too much, but I try and stay balanced.
And how can people reach you?
My office, it is, so I am at Harris Law Firm, and my office number is 614-887-8958.
Thank you. And it's been a pleasure having you on Legal Angle. And I wanted I'm grateful that you came to educate the public about appellate law, civil and criminal. And I appreciate your time. I appreciate your candor. And I appreciate the fact that you have explained the differences between those similar but not similar areas of practice. Thank you for coming on the show.
Thank you so much, Emmanuel. I appreciate the invitation.
Thank you. And for those of you watching the show or listening to this as a podcast, we thank you for joining us. Until next time, stay blessed. And don't forget to follow us on Facebook, subscribe to our YouTube channel, and also follow us on Instagram. Until next time, bye for now.